Welcome to the Power of Offense with Keith and Rodney. And I'm your host, Keith. And right below me on the screen is Rodney.
Greetings.
And today we're going to discuss digital rights. So we're going to define digital rights. And we're also going to discuss how YouTubers can protect themselves by understanding what digital rights are. All right. Now, the reason why this is such a hot topic, something like digital rights, is because of this lawsuit that was filed by Jessica, aka Miss Average at Best, against the popular YouTuber and image consultant Kevin Samuels. Now, we have two videos where we actually reviewed aspects of the claims and allegations that are being made against Kevin Samuels by Jessica. And one of the things that we have discovered that could have avoided this lawsuit would have been if Kevin Samuels would have understood exactly how to protect himself, right, when dealing with others' digital rights. Now, before we get started, let us give you our disclaimer that we are not attorneys at law. We're not here teaching you law or practicing law. Here at the Power of Offense, we entertain you with legal commentary from a layman's point of view. All right. So we're going to get into this, y'all. We're going to get into this subject of digital rights. Now, as you can see on your screen, I typed in define digital rights. Now, there's no formal or official definition for digital rights. But we do have a description of what digital rights should be, or what it is deemed to be, shall I say, in Wikipedia. And right here it says digital rights, right? Matter of fact, let me highlight it for you. It says digital rights are those human rights and legal rights that allow individuals to access, use, create, and publish digital media, or to access and use computers, other electronic devices, and telecommunications networks. All right. Now, this is what Wikipedia is saying about it. Now, I'm going to scroll down. I'm going to scroll down, and I found a definition out of a technology website. And I'm going to click on it. I think this definition provides even better detail on what digital rights are. It says digital rights are the rights of individuals as it pertains to computer access and the ability to use, create, and publish digital media. Digital rights can also refer to allow permissions for fair use of digital copyrighted materials. Digital rights are extensions of human rights like freedom of expression and the right to privacy. The extent to which digital rights are recognized varies from country to country, but internet access is recognized or is a recognized right in several countries. So yes, here in the United States of America, internet access is definitely a recognized right. People have the right to surf the net, right? Just like you have the right to privacy, right? And again, the entire or the proper cause of action that Jessica would seek against Kevin Samuels would seem to be a violation of her privacy, right? And we covered that in the two previous videos. So again, we personally think that this technology website provides a much more in-depth and a better definition to what digital rights are. So we wanted to lay out there exactly what we're referring to. We're referring to the rights of individuals as it pertains to their ability to use, create, and publish digital media. All right. Now, we found an article. Now, this article is called Organizing Photos, right? And it's by the Swedish organizer. So we're going to take a look at this article and what they have to say, right? The Swedish organizer has to say about digital rights. Now, are you signing away your digital rights? I think that's an awesome question to ask. I think that's something that we all should not only ask, but we need to answer, right? Are we signing away our digital rights? Now, it says this past week, I attended the Association of Personal Photo Organizers' fourth annual conference in Anaheim, California, and there was one topic that stood out in my mind as a perfect blog post: your digital rights as a consumer. My colleagues Mary and Jackie made some very important points about how we should all pay more attention to what we are putting online and why. This is actually a topic that a lot of people don't think about or even don't look into very often. I mean, who really reads the terms of service contract, right? I know I'm guilty of skipping through it on more than one occasion, but perhaps we should care. And yes, we really should. I'm going to answer that question. Yes, we should really care. We should know what we're signing up for. All right. Now, in this article, the Swedish organizer defines digital rights. Again, there's no formal definition for digital rights. You know what I mean? So you're going to get variations of what digital rights are, but as long as we understand the foundation of what's being said, then we know digital rights is your ability to use, create, and control your digital media, right? Now, what are digital rights? Every photo service or online cloud service you sign up with will have a terms of service agreement. Usually, you have to put a little check mark in a box and agree that you will use the service according to their rules. But who really reads it? Me, starting right now, and I think you should too. It's extremely important that you look into what you are really giving them permission to do. So let's get to the bottom of this. All right. Now, I agree. Let's get to the bottom of what we're giving these digital platforms permission to do. All right. With our digital rights and our digital media. All right. Now it says ownership of your content. It says, let's start with the basics. Copyright. Who owns the copyright to a photo? Well, in most cases, it's the creator, unless it's a work for hire or copyright has been released in writing. That generally means the photographer who took it, no matter the subject in the photo itself. As we were in Anaheim, my colleague gave a great example with Disney. If you sign up for their PhotoPass service, you can simply hand your PhotoPass card to any official photographer in the park, and they will snap your picture. You are then able to view and download all of your photos after the fact in one handy account. As the designated family photographer, I rarely get to actually be in the photos, so I have to compliment Disney on the ingenuity. It's brilliant. It's a cash cow for them and an extremely convenient service for their guests. Now, I love Disney as a company, but I don't love their terms of service agreement, so let's take a look at it. All right, so we're going to take a look at Disney's term of service agreement. Now it says number 1, online storage. You have to download all photos within 45 days or they will expire. And this is quoted from the Walt Disney Company's PhotoPass terms of service agreement, right here. It says Disney does not offer options for permanent storing of photos or other digital content. Expired photos and other digital content will be deleted from the system. It says they do make this clear up front, and it makes perfect sense considering the sheer volume of visitors they have in the parks, so I don't raise my eyebrows too much at this statement. You can purchase an extension, but only for up to until 60 days. In other words, download the photos ASAP. But no big deal, moving on. All right. So right here, it says number 2, copyright and licensing, right? It says, this is the part I'm concerned about. In all honesty, Disney photographers actually took the photo, which means they own the copyright. It's my educated guess that Disney has a work for hire deal with these photographers so that they own the photo. In any case, it's not your photo, and the copyright holder can do what they want with it. Disney's policy on this also extends to the online world. If you post something on their sites, right, they will be able to use it however they please. Look at what you're giving them permission to do. Now, this is the important part. This is the part that we really want to get to in this discussion, right? about digital rights and how content creators like Rod and myself here at the Power of Offense, how we can all protect ourselves. So content providers on YouTube, right? Listen to me clearly. There are ways for you to protect yourself from being sued from showing other people content such as their image and likeness. And we're going to get into that. All right. Now, this is where it gets interesting. It says, quoted from Walt Disney's company's term of service agreement. Right here, it says, as a matter of fact, let me highlight it since it's the text, the text is in gray. All right, it says, we do not claim ownership to your user-generated content, right? However, you grant us a non-exclusive, sub-licensable, irrevocable, and royalty-free worldwide license under all copyrights, trademarks, patents, trade secrets, privacy and publicity rights, and other intellectual property rights to use, reproduce, transmit, print, publish, publicly display, exhibit, distribute, redistribute, copy, index, comment on, modify, adapt, translate, create derivative works based upon publicly perform, make available, and otherwise exploit such user generated content in whole or in part in all media formats and channels are now known or hereafter devised, including in connection with Disney services and on third-party sites and platforms such as Facebook, YouTube, and Twitter, in any number of copies and without limit as to time, manner, and frequency of use, without further notice to you, with or without attribution, and without the requirement of permission from or payment to you or any other person or entity. So in other words, what Walt Disney is saying is that you own your content, right? That you're actually putting on their servers. You own the content. However, you grant them the right to use your stuff without paying you. This is what you're agreeing to sum it all up. Am I right, Rodney?
Yeah. Yeah, they just use a whole bunch of words. Yeah, but that's pretty much what they're saying.
Now, right here, it says, in other words, they can do anything with it, including selling it, copying it, or making a movie out of it. Use your imagination. They don't have to pay you, credit you, or even let you know about it. Yikes. Makes you think, doesn't it? Because this policy is sneakily hidden in their global terms of service agreement and nowhere near the PhotoPass frequently asked questions is not easy to come across, and it's a great example of how you might get the rug pulled out from underneath you without even realizing it. Copyright is a complex topic, but if you're unsure of who owns a photo, assume that it's most likely the person who took it. When companies as big as Disney, you can bet your money that they cast a pretty wide net. So caution advised, especially if you have children. Now, I find that very, very interesting, right? And I think this is, again, extremely important for people to know, especially as content creators on YouTube, right? So the person that's taking the photo, or the person that took the photo, right, or the person that is initiating the live feed of a video is the one that typically owns the copyright to that image, right? So with that being the case, the argument can be made by Jessica, aka Miss Average at Best, right, that her image and likeness was being used improperly because she never consented to it. Now, again, in the previous videos, we talked about consent. I raised the fact that I believe that implied consent existed, but of course, it's up to the courts to determine.
Yeah.
Up to them to determine. Now, right here, it says, what if you really do own your copyright? It says, who will own it once it's uploaded to an online service? Are you transmitting the copyright by uploading your image? In most cases, no. But you may be striking a licensing deal without even realizing. realizing it. Ever heard of a little company called Amazon? Well, they now have a cloud service for your photos. Here's the deal they want you to make with them. And it says quoted. Now, this is quoted from Amazon's terms of service agreement, right? And I'm gonna highlight this again because the text is in gray. It says, if you do post content or submit material, and unless we indicate otherwise, you grant Amazon a non-exclusive, royalty-free, perpetual, irrevocable, and fully sub-licensable right to use, reproduce, modify, adapt, publish, perform, translate, create derivative works from, distribute, and display such content throughout the world in any media. You grant Amazon and sub-licensees the right to use the name that you submit in connection with such content if they choose. Now, let's talk about that. You know, and I find that very interesting because, again, when you participate in service agreements like this, right, then you waive your right of publicity, right, to receive any type of revenue, remuneration, pay, whatever you choose to call it, from your image and likeness, right? When you, if you choose to use their services, this is what you're waiving. These are waiver statements for those who don't know what that is.